Judge, I forgot to approach you on this other case. It's Miss Loyola. Judge, she has an AFM in our court, but she has a felony.
So she's on bond for an assault of a family member,
Yes.
on bond for a felony assault of a peace officer, and now you pick up a new case.
And what happened was she went to felony.
Oh, hold on, I don't even think we've done probable cause yet. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You now stand charged with possession of marijuana. You're facing up to 6 months in jail and/or $2,000 fine.
Thank you, Your Honor. On March 19th, 2025, a law enforcement officer observed a white Chevrolet Silverado ahead of him on the block 12600 block of Wilcott Parkway and ran the license plate through the NCIC TCIC. Registration was shown to be expired as of June 2024. A traffic stop was initiated and the law enforcement officer made contact with the defendant, the driver. The law enforcement officer observed a strong odor of marijuana, and the defendant claimed at first she didn't have anything in the motor vehicle, then confessed she had marijuana and several pipes. The defendant was detained. A probable cause search of the motor vehicle was done, and the law enforcement officer located multiple marijuana pipes. The law enforcement officer located a small bag of a leafy green substance and a black bag in the back seat. It was identified as marijuana, and the bag was within arm's reach of the defendant. Total weight of the marijuana was 0.09 ounces.
Since she has a license.
Yes, Your Honor. It does show being
Eligible or
ineligible.
ineligible? You're not allowed to drive. You will now be signing an affidavit with me today promising that you're not going to drive. I don't give a rat's behind what your excuses are. If I find that you drive, I can have a contempt hearing. You can be facing an additional 6 months in jail and/or a $500 fine every time you drive. You are on bond for 2 cases. Your first bond violation report was filed in February for you not showing up for testing, and now you picked up a new case. I now revoke your bond on the assault case.
Judge, if I may.
Please.
She went to felony court. And she was also revoked there. She just spent probably 4 or 5 days there. Is that right? And she's out here, so.
The day that missed was, I was in jail for a traffic ticket and I did call.
I don't know if you heard that, Judge, but the day that she missed court here the first time.
No, whenever I missed the
You missed it, that's right. She actually had texted me and she got taken into custody because of a traffic ticket. I have all that. So she was actually on her way to the testing and got picked over, and therefore she couldn't continue to make it there. So she's already been punished for bond revocation on the felony court, which she spent 5 days in jail last week. When did you get out on that?
Saturday.
Saturdays. And so if we take her in, I know you have a right to, Judge. It seems to me like it's kind of like a double whammy for her, especially for the fact that for that first BVR, she did honestly try to make an attempt to get there. I have the phone records for that, Judge.
When someone tells me something and they repeatedly fail to recognize the conditions that we set forth, for me, it goes in one ear and it goes out the other ear. You telling me something when you get out the doors, you still do whatever the hell you want to do without regard to bond conditions in this court. I'm now revoking your bond. She goes with you. Well, hold on. I need to sign this affidavit so she's not going to drive. And then she goes with you. I'm sorry, but it's just one thing after the other.
Do you want to go ahead and just issue a new bond, or can I revisit you in about an hour to figure out what we want to do, Judge?
Sure.
You want to do it that way? Okay.
Is it down with that, please?
She went to court 16.
She did, or we have to wait till you get.
Well, hold on a second. You really want to do a probation with Mr. Proctor?
That's what he said, Judge.
You couldn't even stay out of trouble. You're on bond. Why do you actually think that you can make a probation?
Oh, he's not showing us.
Yeah, I've heard that before. How many times have I heard that before? How many bond violations have we had, Mr. Proctor? You know, you can lie to me, but you can't lie to yourself. You know, if you think you repeatedly fail to appear for court. You repeatedly fail to comply with bond conditions. How on earth do you think that you're going to be able to make probation where you have to do classes, you have to remain clean, you have to report once a month? You can't even report to court once a month. How are you going to do this for 12 months? History says otherwise, Mr. Proctor. Will we do a TRAS on you? Before I do anything, I don't know how to go forward with him. And I think that probably the best way to see is to have Mr. Proctor evaluated to see what conditions and what is the appropriate way to go forward, because I have no idea what's going on in your life. I have no idea what you have, and we don't want to see you fail, Mr. Proctor. We want you to leave better than you came. But just doing this right here, it's just throwing you out there to the wolves. I mean, if you really think that this is the appropriate way, you can even, while you're on bond, for a couple months, stay out. Before, I would like to have him evaluated. So what we do is we have clinicians available that can interview you, talk to about you, what's going on with your life, what has been happening with you, how everything has transpired and how we've gotten here to this point, and to see what's the best way that we go forward. Do we need a treatment plan? Do we need inpatient treatment? Is it sufficient to do out? I don't know. But I'm not ready to do this just yet. I think that we need to have the QRAS to see how we go forward. Let's see what they say. And then at that point, you want to court reporter regardless, right?
Oh, no, sir, no, sir. We will respectfully honor the
So let's-
request by the court.
It doesn't have to take long. I can expedite it so we can have everything done within the next couple days. We're not talking weeks, we're not talking, so we can have everything done quick. Because I don't want you to just sit there and languish. But I need to know how to go forward. And this, I don't think that this is the appropriate way. If they say after we have you evaluated, if they say and they give the blessing, then I'm all for it. I want to do what they advise because they know best. Every time I have someone TRAS'd and I deviate from it, we pay dearly. So that's why I trust them to give us the best advice as how to go forward. All right? Give me a couple days, let me get the TRAS done, we can come back and then we'll go forward. Okay?
Thank you, Judge.
Thank you, I just want to make sure I have the rest of my day, so we put away from TRAS before we do the play.
Yeah, because I want to know what are the appropriate conditions that we put, because this right now, this is the type of probation that we usually do when people have, no violations or, they've been, but here we have multiple, 4 different violations from one thing or the other. So that's why.
Thank you,
Thanks.
Judge.
Okay.
Yes, sir. Thank you, Judge.
Your Honor,
Sheila.
I'm approaching on Mr. Portillo Sanchez.
Judge, was presumptively positive for alcohol, fentanyl, and cocaine use.
Your Honor, he wants to take a plea for 180 days today, which he's got 22 days credit, so.
I don't know.
All right.
I think the last time we had said a year, right?
Yeah.
We set it for trial, I think, on the 22nd-ish, and he wants to plead to 180. No, okay. Will you, is there anything the court would accept? No.
I'm over and over and over. And I don't know if that's what it is that's causing everything in all these cases. But I have a sneaky suspicion that it could be due to all that. You now tested positive for cocaine, fentanyl, what else?
An alcohol, Judge.
Alcohol. You were on bond for 5 different violent cases. Goes with you. I'm sorry, Mr. Portillo. What I would like to do, because obviously now, we now know that there may be a more substantive issue that may be causing all this. So what I'd like to do is have him TRAS to see how we go forward. But I'm not gonna just continue to take these cases where we're basically pleading guilty, throwing him in there 30 days, gets out, he picks up another felony. We have now 4 or 5 open felonies? No. I'm not gonna continue to perpetuate this revolving door of you picking up a case, getting out, picking up a case, getting out, picking up a case, and now you're testing positive. No. We will now get to the root of what the problem is and why you have 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, now 15. It ends today. Goes with you? And we'll have him TRAS. Let's see what it says, and then, you know, and I'm not just gonna continue to do the same thing in hopes that when he gets out, So, send it for TRAS. We'll come back in a couple days, get the report, and let's see what they say on how it goes. Okay, but I'm not gonna just continue to do the same thing and hope for a unicorn, because it's just not gonna happen, you know?
You can come on the call.
I would like to just,
It's up to you.
I would like, I mean, if,
Can, but
right,
let's figure out what's going on.
sure. I just want to see what I mean,
Sure.
obviously as his attorney, I need to see what his options are and meet with
And I
him.
don't want you to do anything you are not kosher, or not happy with, you know? Before we do anything, you know, of course I want your blessing. And if he says no to what they say, then we just go
Have
to
a
trial.
trial.
And we'll go one after the other. Just be ready. Please. Okay.
Should we, I guess, set him like for Friday or something and see, I don't know.
It's probably gonna be the process of today, I don't know if it's tomorrow.
No, there's no way. It's now 11:30. Till tomorrow, he's still gonna be processing. Right. So we can't start the TRAS until he's out. Latest will probably be Wednesday is when we get it done. I would say we probably will have the report.
I'm just gonna wait on mine.
Well, but he'll be set for bail review automatically, right? For Wednesday or?
But if he stays in holdover, somebody can come over there.
We usually have people come here to do the TRAS here.
Right, okay.
Here, to
Okay.
try to expedite it so that they don't sit there for a week or 2 weeks, you know, because we want to, it's not the idea, it's just to hold, just for the sake of holding, is to get everything done quick so you guys can make the informed decision quick. And we'll see, you know, and the idea is hopefully he's honest and then try to get to the cause because,
The option.
you know, before there's a murder case because he's using and he does something that's irreparable, you know?
I
I
understand.
mean, how many times have we seen it? So, okay, thank you. Hi,
Mr. Mayor Coach. Sorry, Judge, I just have,
man.
I'm terrible. I'm in this death penalty capital, so I just don't.
Still?
Yes, Your Honor. We're 2 out of 3 weeks. I just have 4 minutes left on my bathroom break. Mr. Thomas tested, it looks like his marijuana levels are going down, but he did test positive for alcohol. I talked to
Mr. Thomas.
He's present, Judge.
Not only have I reinstated his bond once already, but now we're working a second bond violation warrant. What do I need to do to get your attention, Mr. Thomas? Yeah, right. Justin,
Yes, Your Honor.
what do I need to do? Put his butt in jail?
I think we've been in felony court this morning, so I don't want you to think he wasn't here. He was,
I don't care
he was
about
great.
I care about him continuing to use and continuing to do whatever the hell he wants to do without regard to bond conditions. You do what you want to do. I think I have but one choice, Justin, and to just put him in jail.
Judge, what do you think about some AA meetings or some,
I don't think it'll. When did we order him not to use?
What was the last name again, Judge?
This is Thomas, Mr. Thomas.
Conditions were set in place on October 11th.
This past October, we told him not to use.
The marijuana is negligible, so it's almost out of the system. It was at 0.005, I think. I understand the court's frustration and concern.
If it's been in bond conditions since October, we're now nearly April 1st. It's been 6 months. So it should have been way, way gone.
No, it was from the positive. So you admonished him on the positive not to use, and then, so this is his first test since,
February 6th.
right, and so that's what I'm saying. So the marijuana is negligible. I know it's not an excuse, but I don't know that we read all of our bond conditions about alcohol. Now, I know that's not an excuse because he signed for it. I get it. But I do want to point out to the court that the marijuana is basically out of the system. It was like, that's why I'd asked for the levels, but it was like at a 0.05 or 0.05. It was,
Alicia, do you see that?
The levels, Judge, let me see if it's in the email.
it was, I asked for that, Judge.
I know. I saw that you did. What do you do for a living? Where do you work?
So it's pizzeria, I'm a chef.
What is it?
So it's pizzeria, I'm a chef.
He's a chef at Russo's Pizzeria, and we're in school. So we are being productive members of society.
How do I know that? Am I supposed to take your word for it?
You can take his mom's, Judge. I talk to his mom pretty much on a regular basis.
Judge, now do you see that number? However, truthfully, I don't know what that means. But it is a low number. Monday the 20th. So that's all I have to offer for, but.
Here's what we're going to do, is I'm putting a scram monitor on his ankle, so I know that he's not consuming alcohol.
Yes, sir.
I'm now going to put a GPS monitor and I'm giving you a curfew, because I don't want you out in the middle of the night. I'm giving you a 10 p.m. curfew. If you ever have another bond violation, I'm going to revoke the bond and I'm going to make it so high. Do you understand?
Sir,
I'm sorry.
I will test you again in 2 weeks. If you test positive for marijuana after 2 weeks, then that tells me that you've continued to use, and I'm going to lock you up. Do you understand?
sir.
Thank you, Judge. Maybe excuse to go back to very important cases.
So he's back in 2 weeks to test. If he tests positive after the 0.05 nanograms or whatever the hell it is, if he's still testing positive.
I have nothing left to say, Judge.
All right.
I will be speechless.
All right.
Your Honor, I am here on Mr. John C. Joseph, alleged BVR violation, Judge. Sitting over in the jury box. It's my understanding that he left his area curfew area on 9:07 p.m. on 5/20 came back at 9:31, approximately 24 minutes. I spoke with him. It's my understanding that he went over to his sister's house because he and his girlfriend had gotten into a heated discussion. He informed me.
Mr. Joseph.
He informed me that he left to stop proceeding assault, possibly assault between the two.
I do everything in my power to try to prevent people from going back into custody. But some people just refuse to just, I don't know what I can do to get your attention. We now have 2 open cases, and now this is your second bond violation. What do I need to do to get your, what do I need to do to get your attention? Is it putting you back in jail, Mr. Joseph, and making your bond high? Sir. Your actions tell me differently. This is what we're going to do. I'm sending him now for a drug and alcohol test. I want to know what, if anything, is in the system. You were to come back. If you fail to test, if you fail to take the test, if you fail to come back, it's not going to go well for you. Do you understand? I don't want you to say anything. I want you to go take.
I'm offended. I don't have time for Liz to get on my sister back.
You have been on bond, Mr. Joseph.
Okay, so yeah.
I think the last time he was in court, Judge, I think he made an admission that he had used drugs during that court appearance. And if that's the case, he may be correct in that it may still be in his system, Your Honor, because it hasn't been 30 days.
The first burglary of a motor vehicle has been open since June of 2024. Since that time, I have told you not to use.
Okay, I'll.
Take a seat for me. I don't know what we're gonna do. Take a seat.
Thank you, Judge.
You were here in June last year. You have a violation because you came in late then. Now we have another set of bond violation for you coming in late.
Was he,
Why would I continue to let you go? I let you go already once and you did it again.
instead of voting, we'll put it on Thursday.
Do you see what I mean? Because me, if I let you go, then I'm telling you it's okay for you to do what you do, when it's not.
Judge, if I may, I believe that he has a legitimate reason. I believe that if he had not gone, there was the possibility that an assault or some other harm could have happened to his girlfriend. From my conversation with Mr. Joseph, he informed me that he left, and it was just for only 24 minutes. He left in order for both of those parties to cool down before a fight or an act of violence escalated between those two parties. I personally think that that was the right thing to do.
Hold on a second. Who do you live with at home?
My girlfriend, but my sister stay right down the sidewalk in the same apartments.
House in complex.
Yes, sir.
She doesn't live with you.
Huh?
She doesn't live with you.
No, not my sister.
So who is the fight with?
It's my understanding that it was his girlfriend.
Is it the family here?
My girlfriend here.
So the fight was with who?
It wasn't a fight, it was a words that was about to escalate into a fight, at which time he left for a cooling off period with his
My
girlfriend. And he left, nothing serious could have happened. I believe that was, even though it was a violation of the bond condition, I believe that it could have been worse had he not left.
If you put your hands on anyone, I don't care who it is, if it's a woman, if it's a man, I'm gonna put my hands all over you. You understand?
Yes, sir.
Nothing in this life can justify you putting your hands on anyone. You have
Man, no,
two,
I just live so the situation can cool down.
you have two open cases. At all times, you need to be thinking to yourself, if I do this, what's gonna happen? If I say this, what's gonna happen? If you're going to antagonize, meaning if you're going to say something that makes someone flip out on you, and the laws come over, and they see you, and they look you up, 9 times out of 10, they're going to go against you. You need to be thinking of these things at all times. You get into a fight with them, in words, it's always going to end up bad for you. I understand and I appreciate de-escalating the situation, meaning you're leaving so that it doesn't end up in anything more, but it shouldn't be like that in the first place. Are you working?
No, I just did 3 job applications. I'm waiting on the interview to be
Mr. Judge, yes, sir, I know you are.
I don't care.
I do, Judge.
Why aren't you working?
I just recently started looking for jobs.
You have too much time on your hands. You need something to do in this life before it takes you down. When you have too much time on your hands, you become self-destructive. You need something to do in this life. It's time for you to start working, and I want to see that you get a job. Toria, can we help him out?
Yes, I'll give them some resources.
We're going to give you resources to try to help you get a job. There's no reason why you can't have a job within the next couple of weeks if you try. When you put your heart and soul into it, you can achieve damn near anything. It's just how badly do you want it? That's what it amounts to. And when you do get a job, if you really do a bang-up job, and if you do well, and you don't do stuff half-assed, all you're going to do is you're going to go up, and you will make more money. The higher you go up in the job, the more money you're going to make. And then everybody's happy. When you get to buy nice things, that's what life's about. Not the janky, stupid-ass jobs where you're making $6 an hour. No. Work hard so you can make a lot of money. All right.
It's great.
I'm not going to ding you. I don't want any more issues. Do you understand, Mr. Joseph?
Yes, sir.
I'm bringing you back in 2 weeks, and I want to see that you have a job. 2 to 3 weeks. If I see that you haven't put any effort into it, it's not going to go well between us. I also don't want you to use any dope. Do you understand?
Yes, sir.
If I find that you're testing positive, likewise, it won't go well for you. All right, Mr. D.
Thank you, Your Honor.
Good.
Just approaching on a new fugitive case, it's Robert Mizell. And Judge, he would like to have a bond set. It's kind of an odd one, Judge. It's failure to possess the required license for home improvement or residential construction. And basically, Judge, he told me that he owned a construction company, but he's totally blindsided by this charge.
Good morning, Mr. Mazzell.
Good morning.
Your lawyer's asking for me to set you a bond. You're now stand charged with, I guess you said, home improvement fraud.
Judge, essentially, that's what it sounds like the allegation is. It's a failure to possess the required license for home improvement.
I have your fraud.
This was in 2020, during the 3 hurricanes that hit Louisiana. And according to City Hall, and we went down to everybody, and they said we didn't need one because it was an emergency situation. Everything was flooded and devastated, and we were just trying to help out.
My only issue is that this is now a second fugitive case that you have.
The first one was a lady that we did work for.
Let's be careful.
Doesn't matter.
Oh, sorry.
Mr. Mazzell, is that, we usually, as a matter of courtesy, I guess, so to speak, we'll give you a chance when you get one fugitive case. But we can't continue to do the same thing over and over and over.
Understood.
Amy, what do you know anything about this?
Yes, so first I'll state as opposed to a bond. This particular case, it is because he didn't have a license, but it originated out of the fact that the complaining witness, after a hurricane, had paid the defendant money to repair her house. He did not do so. The money amount was...
So he allegedly took money for fixing the house and didn't do the work.
Correct. And then when the officers went to go look him up, he didn't have a license under that name. So that's the basis for that charge. We are, of course, opposed to a bond given that he has had a prior fugitive case. He was granted a bond on that one, but he didn't actually show up. Looking back at our notes. The only reason...
So we gave him a bond, he bonded out and he didn't show up?
No, he appeared, yes, he appeared in court on that day when you guys provided him a bond. He appeared in our court here in Harris County. The only reason that case was dismissed is because I believe that the main jurisdiction in that case had recalled their warrant or something of that nature.
But so he didn't turn himself in?
No.
The lady that was charging us, I ended up paying her $21,000. And she dropped the case.
How? Am I supposed to, we can't just take everybody's word for what
But first off, I did not know that even the warrant existed. So I had no idea. But I ended up paying the lady off. I gave her some money and said, okay, that's good, we're fine. I truly didn't think we did a very good job.
Okay.
But may I ask you this? This is an LLC. I have had a business partner at the time. We were 50-50 in the business. I just wonder why I'm the only one being charged here. I mean,
facts beyond what I would know anyways. The simple thing about it is that I gave you a bond last time. You bonded out.
Yeah.
You didn't show up. And now you have another fugitive case. We can't continue.
I bonded
we
out
can't
and I
continue.
paid the lady off and she dropped the charges.
That case was dismissed? Is that
Yeah, the
correct?
case was dismissed.
Not because he showed up like he was supposed to.
I see what you're saying,
He came
Judge.
to court on the day that he was due to go turn himself in Louisiana. I don't know, but I can't continue to do the same thing. The good news for you, Mr. Mazel, is that it's Louisiana. So we have buses coming from Louisiana probably 2 times a week. So from the time that you waive, within the next probably 2 to 3 days, you'll be back in Louisiana to be able to answer the charge. But I'm not going to just continue to give bonds on fugitive cases when you continue to pick them up. Because
Got it?
okay. Has he waived or did he refuse?
To refuse extradition.
Okay, so you need to decide what you would like to do. If you want to waive extradition, I would say probably within the next, 3 days, Louisiana will be here to come get you. If you want to refuse, which is well within your right, the state can get a governor's warrant, but that'll take 90 days. And at that time, they can have you remanded
I can
back.
sit in jail for 90 days. No, I'm not interested in that.
So, but I'll let you talk to James to figure out what you guys want to do, and then you just let me know.
Okay.
Mr. D.
Yes, sir, Your Honor.
So much here for like another.
Your Honor, I'm trying to find out where are we with Sean Sullivan?
Sorry.
Yes, okay, Judge. Sean Sullivan, Judge, is my
You
understanding.
got it, okay.
Yes, I have the case. I wanted to know, were you concerned with DVD? Did you want to get any DVD involved?
Michelle?
Yes, is this the
Yeah, this is the one that we were talking about.
We'll let it stand. They just want to see it. Gens, so they don't have anything else to add.
Okay.
So I had a concern because is it mutual combat? Because
It looks like from my understanding, Judge, looks like the complaining witness is the person who actually initiated the contact. She was alleged to have been lying on the couch or not dressed appropriate in the presence of 2 other male men that resided in the residence with them. And he tried to wake her up to let her know that she was dressed inappropriately. And out of slumber and sleep, she woke up angry and started hitting him, and that's when the altercation.
she pops him 3 times in the mouth initially,
Yes, Your Honor.
and then they fight.
And the police-
There's no assault from him at that time, right? I guess they separate, they part ways. An argument ensues later.
Yes, Your
Does she go at him and that's when he hits her?
That's not what we
So
have.
tell me that one part. What happens then?
Yes, Your Honor. So it seems as though the complaining witness, she crawled into bed and was laying on the corner of the bed when, after about 10 minutes go by, then the defendant comes back and begins to argue with her, crawls onto the bed, grabs her, flips her backwards on the mattress, and uses body weight to lay on top of her while placing both of his hands on her upper arms to hold her down.
So there's no,
And there is a subsequent punch where the defendant uses his right hand and punches the complaining witness in her mouth, causing pain and visible.
It's my understanding, Your Honor, that this incident occurred on a date certain, at which time the complaining witness told the police officer that she did not want to press charges and he did not want to press
right,
charges.
but
And they came back the next day.
why is it that they didn't file assault charges on her on the first? I mean, are we going here just because she's a woman? She gets a slide for getting to hit him? You know?
Was there, I don't know why the city.
I know there was no arrest on the initial date the incident is supposed to have occurred. The arrest occurred the following day. The first date, the officers did not arrest either party, but some type of disturbance occurred the next day. Officers were called, they came in and they looked at the report and they arrested the defendant.
My guess is, like limited knowledge of intake, they probably put a call in the intake, they said, no, it's just my guess. Refer out, do follow up, and then they went back out there next day, saw the referral on file, and they decided again.
So he goes up to her and he sits on her. Is that what you're saying? What happens? He turns her over.
More so, she's on her, from what I understand from the devs, she's on her stomach, he turns her over to where she's on her back, and then he gets on top of her and holds her.
He's straddling her like this.
Yes, Your Honor. And then subsequently after that, they were still arguing and we touched the putting with his mouth.
I don't see where that's, if she was the initiator of the confrontation between the two parties, it's my understanding it's my understanding, from the complaint, from the defendant's perspective, it was not a hit with a fist, it was a push that caused various injuries to her mouth, but he did not take his fist and punch her.
That's, of course, but he's saying to you, right?
Right.
And then you're saying that there was a hit to the mouth.
And she didn't press charges. She requested that no charges be filed. Somebody get punched in the mouth. If that were the case, you would think that someone in their right mind would say, yeah, arrest that person. However, if that person realizes that he or she is partially responsible for the incident, then that would probably lead them to say, okay, I started this mess, it shouldn't have started. I don't want to press charges.
10 minutes pass, right?
Allegedly.
And I don't know why they didn't. Come up, Mr. Sullivan. Let's do this. Let's set it for a formal probable cause hearing. Okay. I'd like to do some additional research as well before I find probable cause in this case. So what I'll do is I'll put this case on for Wednesday for a formal probable cause hearing. In the interim, Mr. Sullivan, I'm ordering you not to have any contact with this person whatsoever. You understand?
Yes, sir.
I don't care what's going on in your life.
I got you.
For the moment, I'm gonna, I don't want you to have any contact. I don't want you to go where this person lives, where this person works. If I find that you do, I will revoke your bond and put you in jail.
Yes, sir.
We'll come back in 2 days. I would like to do some further research on it because, I really like to look at every case, do a deep dive to ensure that there's probable cause before we go forward. So, I don't blindly find PC for anyone. I'd like to do things in the fair way, but at the same time, I want to ensure that my county and every person in it is protected. So don't have any contact with this person. We're going to create bond conditions to this effect. They're probably going to reach out to her between now and Wednesday, and if they find that you're trying to communicate with her, it's not going to go well. Do you understand?
Yes, sir.
Do you mind filing no contact in the weapons, please?
Yeah, sure. No context, I'm sorry.
No weapons.
No weapons, yeah, sure. Thank you.
One of the things that they teach us is, never make rash decisions because it may be the wrong decision. And that's why I'd rather take a little bit of time before we do something to ensure that what we're doing is the right thing to do. So we'll put it on for Wednesday, come back Wednesday, and then we'll have a decision for you.
Thank you, Your Honor. Appreciate it.
I've given you a lawyer, so just stay in touch with Mr. D, and then we'll come back, and then we'll finalize it for you.
Thank you so much.
Don't leave until you sign our bond conditions, okay?
Thank you, Judge.
We appreciate that some message files, they know what's going on.
Yeah, great. Maybe they can be here Wednesday to add anything further, and then we can, okay.
Judge, I am here on our friend. I feel like almost like he's family. Daniel Frazier.
Okay.
He was charged with another escape.
I didn't know, we got him back.
Yes, sir. Yes, sir. I was surprised to see him pull up on my docket as well, but not really.
Will you stay on it?
Yeah, I'm on, Judge. We have a decent relationship. Even though we believe we know how this is going to go, at least from you, because right now the bond is set at $50,006 and $50,000 in the felony court. He wants me to ask you for a time served. I believe I already know what the answer is going to be. And in the event that you deny my request for a time served, he said he's willing to go back into treatment and he's willing to complete treatment this time. Now, I don't know how that's going to affect him upstairs because
ours until the upstairs is taken care of, because they won't take him with an open felony.
Understood.
Standstill until.
And the big problem is I'm not representing him upstairs, his court date is like May the whenever, it's like really far down the line. Yeah, so.
Get you going. Do you mind bringing up Mr. Fleischer, please? Okay. Thanks. How are you?
I'm good.
You're back.
Yes, sir.
Good to see you. How are things?
Good.
Good. What's good to see you?
We're good.
Say it again?
I said they were good.
You know, you can run, but the long arm gonna get you every single time. You can only go so far. Sorry, no time, sir. You know how it goes. I told you, every time we come back, we're gonna do it until it takes. And, you
So
know,
my only option, in all honesty, my only option for this, for the misdemeanors treatment, there's no other option. No matter what. No matter even if I got treatment on my own.
really? Really?
I mean, I've done it already. I've done it once. I've done that. I've got behavioral treatment and I've also got mental health. Behavioral and also substance abuse treatment.
Yeah.
I've done both already.
I want to use ours. The problem is that I cannot do anything until the case upstairs is taken care of. So we're kind of in a holding pattern until upstairs. Hopefully, they will see that that's what we want to do here, and they'll, you know, but I don't know. I can't. You're not representing upstairs, right?
No, sir.
So, we gotta wait to see what happens upstairs. And then we'll just, told you, we're just gonna keep doing it until it takes. Hopefully one day it does.
I really don't. I don't have a substance abuse problem. I really don't. And honest to God, I don't. Like, I've stopped a long time ago. And honest to God, I've stopped and I'm not trying to go that path. Honest to God, I don't have a substance abuse problem issue. I've stopped.
So, I guess let's set it for 30, Mr. Brooker. We'll wait. Because if they take care of it beforehand, you know, we'll see. And then if it's still set for the May 17th, we'll set it for the day after at that point. And then we'll see, hopefully, you know, reach out to the lawyer upstairs, let them know this is what we want to do here. Hopefully they'll see that that's what we're trying to do. And then, you know.
So basically, I'm waiting for the appellate to see what happens.
Hopefully they will see what we're trying to achieve and be on the same page as us. You know, this is the second time you're facing this charge upstairs. They may offer you 4 years, 5 years upstairs, you know, it's no joke. You know, I'm trying to help you, Mr. Fleischer, believe it or not. You know, really. You're facing a lot of time and it's not the first time, so if you try to, you know, we played this game the first time, I don't know if they're gonna.
Yes, sir.
Anyway.
It's a different court, Judge, so I'm hoping that we can have a similar outcome. And if they do it beforehand, I'll come off
I
document.
want to do it, and hopefully if they see that you're really willing to. So, all right.
Yes, sir.
I just want to say hello, that's it.
Yes, sir. All right, thank you.
We'll see you in 30.
Judge, I'm approaching on a plea for Mr. Lacero Intimendia.
I'm ready when you are.
All right, I'll call him up, Judge.
You were charged with driving while intoxicated. It's elevated to a Class A misdemeanor because of the high blow. You are facing up to a year in jail and or a $4,000 fine. You have worked out an agreement where they're off you 9 days in jail. Days that you have done. You need to understand what's going on in your record. Be there for the rest of your life. You get into a car, you drive, after having consumed half of a beer, you get pulled over, an officer sees a product that you haven't smelled anything in your car that's wrong. You understand?
Sí, señor.
Yes, sir.
Have another DWI, and you do anything more than 6 hours in jail, you will probably get an immigration detainer if you're not in this country with permission. Consider these things when you're out there in the free world. You understand? From now on, it is a minimum of 90 days in jail for any new cases that you pick up. No more proverbial slaps on the wrist. You're giving up the right to a trial,
Tienen derecho
right to compel witnesses to testify on your behalf, confront and cross-examine your accused.
testigos a sus
If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty, it will go on your record forever and a day. You understand?
¿Entiende?
Sí, señor.
This is what you want to do.
¿Esto es lo que usted desea hacer?
Sí, señor.
Yes, sir.
How do you plead to the offense? Guilty or not?
¿Culpable o no culpable? Guilty.
I'm going to find
Voy a
you.
hallar que es culpable, suspender su licencia por 90 días.
Do not drive
No maneje.
until you get a license and insurance in your name. Otherwise, you will be back here and it's not going to go well for you.
Driver muy bien.
Good luck.
Judge, the only thing is, I'm appointed on this case. I wanted to see if you'd consider waiving the Supermax fine for him.
What do you do for a living? You said you
¿En qué
didn't.
trabaja usted?
Ahorita no estoy trabajando.
Right now, I'm not working.
The order is asking
abogado está pidiendo
for
que yo
waive $4,500 to around $5,000
hasta $5,000
that would otherwise apply to you.
que serían
It
aplicables
is a first
a usted
DWI,
como
so
esta
I will.
primera.
But
Los
if you
años
come back with
regular. Si regresas con otro delito de conducción,
$1,000 surcharge,
son
the
$6,000
second DWIs, and if you don't pay it, you do 1 day in jail for every $100 you owe.
Si no lo pagas,
So you will find that you
$100
spend
cada día.
months in jail and you pick up another one, potentially. Do you understand? I'm not
Yes, sir.
asking for much. I want my streets safe. If you're not gonna comply, then I have a place for you. Good luck.
Thank you, Judge. Appreciate it.
Good morning, Avalon.
Good morning, sir.
Sir, you are in February charged with terroristic threat of a family or a household member. It's come to my attention that you have now picked up a violation of a bond condition or a protective order. I have no idea what happened, but I want to find out. You have the right to remain silent. Anything you say can or will be used against you. I want you to know that you're not here alone, okay? Okay. So, you're alone.
well-
Not you, okay. So, you have the right to remain silent. Exercise.
well-
Not you.
On March 29, 2025, law enforcement officers were on patrol. On March 29, 2025, law enforcement officers were driving south when they observed a white Outlook City street located in Harris County. Driving south, the law enforcement officer ran the vehicle's license plate street located in Harris County and observed the vehicle's registration ran the vehicle's license plate through NTIC and observed initiated traffic stop and activated their emergency equipment. Law enforcement officers initiated a traffic stop and followed and activated their emergency vehicle that drove into a gas station parking lot and followed a stop. Law enforcement officer approached the that drove into a gas station parking lot and pulled over a seat wearing a seatbelt. Law enforcement officer approached the defendant's vehicle and observed the passenger sitting in the front seat wearing a seatbelt. The defendant who identified herself as Stephanie Avalar, passenger, and who identified herself as Stephanie Avalar. That was confirmed by the law enforcement officers. The law enforcement officers also found that by the law enforcement officers. The Ferdinand came back as a particular person, found that it balanced that Ferdinand came back as a identifying information, balanced the driver, and the identifying information came back under the driver as the defendant. Well, they came back the law enforcement officers repurposed the vehicle and detained the defendant. The law enforcement officers repurposed the vehicle and detained the confirmed that one of the law conditions and the fixed order confirmed one of the law conditions and
So shifted Blackbird shield lead, so we had issued the no contact, right?
Yes,
So
sir.
shifted Blackbird shield lead, so we had issued the no contact, there is
Yes, sir.
sufficient probable cause to go forward. You have to understand, I'm gonna have court orders, sufficient probable cause to go forward. You have to understand. It's not hard, you have lawyers, when we mean it, something changed, talk to the lawyer. It's not hard, you can come to us, when we want your things out, we can change things. Talk to the lawyer, but the lawyer, when you try to do stuff on your own, we hear things out and you can change things. It's quick, but as you know, when you try to do stuff on your own, everything goes sideways, and it goes sideways quick, as you now know. So,
Your Honor, we will be, we'd like to approach off docket tomorrow to try to have the law amended. We'd like to approach off docket tomorrow the state to try to have the law amended, the CW, but they have not been able to speak with her to clarify that she would in fact like him to be able to come home. They have not been able to speak with her to clarify that she would in fact like him to be able to come home and have contact and the like.
so what happened is
So terrorist threat, he appeared in PC court.
So what happened is
He received a PR bond, appeared in PC court, appeared on arraignment February 13th. You got to receive a PR bond.
right, but I'm showing now he's bond active after the new. Right, but I'm showing now he's bond active after the new. Well, look, it shows bond made on terrorist threat.
This case was never, that's from.
Look, it shows bond made
He
on
was never
terrorist
revoked after
threat.
since taking case. This case, that's from the previous PR bond. He was never revoked after since taking case. This case has still been on bond.
Did they not address it? And I'm at a loss if they never addressed it. Did they not address it? And I'm at a loss if they never addressed it.
This is only recess for April 23rd.
Mr. Woodward, my concern is
This is
that,
only recess for April 23rd.
they gave Mr. Woodward, my concern is that, they gave him a terrorist threat on the terrorist threat. I don't even show that a PR bond was given. Oh, here we go. On 213, I don't even show he's picked up a violation of protectable. Oh, here we go. On 213. So I can't continue to give you a PR bond. A violation of protectable, man. So I can't continue to give you a PR bond. No.
Sorry,
You need to talk to your lawyer before you talk.
Can I ask, it's because I made bond.
No.
Sorry.
You need to talk to your lawyer before you talk, because I don't want you to say something that hurt your case. You do things a certain way. You can't do stuff on your own, but you've been through the system long enough to know that. You do things a certain way. You can't do stuff on your own. You've been through the system long enough to know.
But I paid for my bond.
Hold on. Are you on parole at this time? No PR bond.
I'm sorry, I'm not on parole, but I paid for my bond.
Let's do this. Your lawyer said you can be here tomorrow. So we'll have him come here tomorrow. Let's do this. Your lawyer said you guys can read through, try to figure something out. So we'll have him come here tomorrow so he can.
So, Mr. Woodward, you say you can be here tomorrow?
Try to figure something out.
You want to address it, I guess? So, Mr. Woodward, you say you can be here tomorrow?
Okay.
Absolutely.
So we'll roll you to
Want to address it, I
tomorrow.
guess, then?
We'll try to figure
Yes.
something out.
Judge, you're supposed to
Okay.
get released today.
So we'll roll you to tomorrow.
On the BPO.
We'll try to figure something out.
Judge, you're supposed to get
I'm not
released
giving him
today
another PR bond when he picked up a VPO though.
Do you want me to revoke the?
I'm not giving him another PR bond when he
Your
picked up
Honor.
a VPO though.
Do you want me to revoke?
Yeah, the PR.
I mean, I certainly understand, Your Honor, how you work, but since I'm not there with my client, I certainly understand to experience that. How you work. The facts of the I'm not there with my client, I just like for him to experience that. CW, the facts of the underlying case, they had an argument. She grabbed his hair first, pulling the relationship. Grabbing her argument. She grabbed his hair first, sent from an unknown number saying, "Don't come home, grabbing her." But she's my text message was sent from an unknown number saying, "Don't come home, PC, fuck you up, Your Honor." She's my English, Your Honor. That's what was for the terroristic threat case. PC, Your Honor.
Of which one?
For the terroristic threat
I don't
case.
know. I guess what happened in the terrorist threat?
Yes, Your Honor, find yourself one moment.
I don't know. I guess what happened in the terrorist threat?
Yes, Your Honor, find yourself one moment.
My understanding is that the CW is willing to communicate, that there was a little bit of a misunderstanding of the facts. I believe the state called her once, she said she was a little bit of a misunderstanding with the facts. I believe the state called her once, she said she wasn't able to communicate, she would be a bit of a misunderstanding. I don't think that, she's been able to communicate that there was a little bit of a misunderstanding of the facts.
Your Honor. What I have is that, Your Honor, from the threat was made during an altercation where the defendant told the complaining witness. The threat was made during an altercation where the defendant told the complaining witness.
You're good, dude. Don't be shy. Come on. We all know the F word.
You're
You're good, dude. Don't be shy. Come
I
on.
understand that could be made during an altercation.
If you don't, it was
I
made.
understand that could be made during an altercation.
Don't come home. Definitive minutes, it was made during the complaining witness. I'm going to fuck you up if you don't. Definitive minutes.
Your Honor, I'm looking at the summary of facts. It literally says on her cell phone contact. Your Honor, I'm looking at the summary of facts. It literally
via cell phone. On her cell phone, which he stated, complainant stated the defendant then began to threaten her via cell phone. I got you. I'm text which he stated, complainant stated she was fearful for her safety. Go kick before that line, it says if they came from an unknown number. Stated she was fearful for her safety. But before that line, it says they came from an unknown number.
Further down in the summary of facts that there. Your Honor, it is further down.
Of course, Mr. Woodward, someone can make something from an unknown number, but they can corroborate. Of course, Mr. Woodward, someone can make something from an unknown number, but they can corroborate at the same time, you know? And I think that that's what the state is saying here, that he corroborates that I'm gonna go fuck you up. The actual text message.
Yes.
Saying that I'm gonna go fuck you up. The problem is that we have him, he's still doing stuff on his own. You know, problem is that we have him, he's still told him not to do his own, admonished him not to do it, and he's still, you know,
yes, sir.
Told him not to do it. In this life, when you do things the right way, good things happen. You know, when you do stuff the way you want to do it. In this life, when you do things the right way, good things happen. When you do stuff the way you want to do it, in violation of orders, and you've been through this. The end of the world. Sufficient. How do I get your attention? You know, so that you realize that we mean the end of the world. If I just give you PR bond after PR bond after PR bond, so that you realize that we mean business. If I just give you PR bond after PR bond after PR bond, I mean, we have no
paid out of my pocket to get bonded. They gave me a bond downstairs and I paid for it.
You're on your VPO, but I'm not going to give you a PR bond when you're.
They gave me a bond downstairs and I paid for it.
You're on your
She called me
VPO,
her
but I'm not
home
going
had
to
it.
give you a PR bond when you're picking up a VPO. Like I said.
She called me her home had it.
I'm not telling us stuff because I don't want you to put it in your mouth. Talk to your lawyer first and help regardless. Now telling us stuff because I don't want you to come back tomorrow. He's going to come here and help regardless. Now look, work something out. We can come back tomorrow. He's going to come here.
I was just trying to help, sir. I've been staying away from her. I got like 10 days left.
Sir, I got you. I'll come check up on you.
I've been staying away from her. I got like 10 days left.
Sir, I got you. I'll come check up on you, okay?
Back tomorrow. You'll definitely be here tomorrow, Mr. Woodward?
Absolutely, Your Honor.
Okay, so I'm going to revoke it for now. You'll definitely be here tomorrow, Mr. Woodward? We'll talk.
Absolutely, Your Honor.
Okay, so I'm going to revoke it for now. A place so they can reach out to the complaining witness so they can get a rip done? Do you have a place so they can reach out to the complaining witness so they can get a rip done?
I do not have it readily available, Your Honor. I can likely get it.
Okay, so don't, I mean, can you
I
try
do
to
not
do
have it
rip
readily
between now
available,
and
Your Honor.
tomorrow?
I can likely get it.
Okay, so don't, I mean, can you try to do a rip between now and then we'll go tomorrow? So we can try to figure out what she wants. And then we'll go forward? Okay, all right, we'll see you tomorrow.
Thank you, Your Honor.
Please. All right, bud, we'll see. Good morning, Ms. Stevens. Okay, all right, we'll see you tomorrow. Man, you're charged with
Thank you, Your
theft.
Honor.
You're facing up to 6 months in jail and or $2,000 fine. Man, you're charged with theft. We're going to do facing up to 6 months in jail and or $2,000 fine will be used against you. We're going to do probable cause you have the right to remain silent. Anything you say can or will be used
On
against
March
you.
18th,
The right to have an attorney
2025,
present. If you cannot afford one,
an officer was dispatched with theft. On March 18th, 2025, at 5:21 p.m., on officer was dispatched with theft of a female identified by the female in custody. On officer searched the defendant for passing custody identified by the officer's driver's license. That officer searched the defendant for passing custody of an officer who stated he was following. That officer spoke to the store and observed her concealing items in her purse and backpack. He was following the defendant. This was done in a blind store and observed her concealing items in her purse and backpack. The defendant then continued shopping before checking out cameras and paying for some items. Videos. The defendant did not pay for the item. Continued shopping before checking out and paying for some items. For the loss prevention officer, did not pay for the item she had considered admitted to stealing before turning the items back over. The loss prevention officer, total value of the items was $120. The defendant admitted to stealing before turning the items back over.
I'm going to find that there's sufficient probable cause to go forward with the case. Thank you. I'm ordering you now to find that there's sufficient probable cause to go forward for any reason whatsoever. I'm ordering you now. If I find that you do, I will revoke it into jail for any reason whatsoever. If I find that you do, I will revoke it. Likewise, if I find that you know any other cases, your bond will be revoked. Will go. Likewise, if I find that you have any other cases, your bond will be revoked. I will have you fill out an application. Deputy Miranda's going to give you an hire lawyer. I'm going to have you sign a receipt with Victoria. I will have you fill out an application. Deputy Miranda's going to give you an application. Your bond. I'm going to have you sign a receipt with Victoria until you sign. After that, we'll have you take a seat in the jury box while we get your bond application ready. Do not leave it to any Walmart. Okay? Anywhere, please.
No Walmart.
Filing for anyone. Nothing to any Walmart. Anywhere. Frank Reyes.
No Walmart.
Mr. Reyes, you're charged with driving while intoxicated. Second offense. Frank Reyes. Facing up to a year. Reyes, you're charged with driving while intoxicated. Second offense. We're going to do probable cause you have the right to remain silent. Anything you say can or will be used against you. We're going to do the right to have an attorney present. If you cannot afford one. Anything you say can or will be used against you. Okay, the right to have an attorney present if you cannot afford one.
Officers dispatched to a minor crash in Harris County, Texas, where the defendant had rear-ended the complaining witness. Officers dispatched to a minor crash in Harris County, Texas, the driver's seat and veering in and out of consciousness. On contact, the officer out the defendant to driver's started his car and slipping in and out at that point. The officer wrote the defendant out. The defendant did not notice any injuries on the defendant. At that point, the defendant exited the car. He was unsteady, not notice any injuries on the defendant. The defendant exited the car. Bloodshot eyes, and officers observed and admitted to drinking at a bar earlier. Bloodshot eyes, standardized for sobriety tests were conducted. Admitted to drinking at a bar earlier. Observed 6 out of 6 standardized for sobriety tests were conducted. Debate on the walk and turn. 4 of 4 observed 6 out of 6 on the HGN. The drug processing center, the defendant fell asleep on the one stand. At drug processing center, the DIC and the officer's vehicle. However, the processing center again officer read the DIC and transported to the hospital, and a blood warrant was signed and fell asleep again and began vomiting. So the defendant was transported to the hospital, and a blood warrant was signed and executed.
Mr. Can you run his license for us based on valid license?
No, Your Honor. Yes, Your Honor.
Mr. Reyes, I'm going to find his license sufficient probable cause to go forward because you are not allowed to drive unless you have a valid Texas driver license and liability insurance. You are not allowed to drive unless you have a valid Texas driver license and liability insurance. You're not allowed to drive any vehicle from now on. I'm going to give you a quote with an ignition device. You're not allowed. If you're caught driving a vehicle that doesn't have an interlock on it, I'm going to put you in jail and I'm going to make your bond high. If you're caught driving a vehicle that doesn't have an interlock on it, I'm going to put you in jail and I'm going to make your bond high. You are not allowed to drive. You will be signing an affidavit with me today promising you're not going to drive, Mr. Reyes. You will be signing an affidavit with me today promising you're not going to drive, Mr. Reyes. Have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine. Have a contempt hearing. Time you can be facing an additional 6 months in jail and a $500 fine every time you get into a car and drive. For any reason. Do you understand? I don't care if there's a burning building and you have to say 50 babies driving. Do you understand? For any reason. I don't care if there's a burning building and you have to say 50 babies. I'm sending notice now to DPS. Do you understand? So that every single officer in the state knows. I'm sending notice now to DPS. You are not allowed to drive a vehicle that every single officer in the state knows. If you're caught driving a vehicle, you are not allowed to drive a vehicle that doesn't have an interlock. I am now giving you a portable device. It doesn't have an interlock. They will arrest you to prove to me that you're not consuming alcohol. I am now giving you a portable device that you're going to take with illegal drugs as well. Prove to me that you're not consuming alcohol. You consume alcohol. You will also be jailed for illegal drugs as well. You test positive. You consume alcohol. Into jail you will go. We're going to give you time. I'm going to have you come up here to Square to say you're not going to drive. I'll get you to Victoria. We'll have you sign a reset. You will get with. I'm going to have you come up to Square to say you're not going to drive. I'll get you to Victoria. We'll have you sign a reset. You will get with Felicia for your bond conditions, and after that, good morning, Mr. Sullivan. Sir, you were charged with assault with a family member. You're facing up to Mr. Sullivan. Sir, you were charged with assault with a family member. Cause you have the right to a year in jail. Anything you say can be used against you. We are going to direct having an attorney present. The right to not afford one. Anything you say can be used against you. For the right to have an attorney present, if you cannot afford one.
On March 23rd, 2025, at approximately 50:39 on March 23rd, 2025, at approximately Harris County, Texas, 50:39 hours, the law enforcement officer was dispatched to an address in Harris County, Texas, arrived on scene. Who stated on scene, husband, defendant, arguing because her adult daughter does not like the defendant, arguing because her adult daughter does not like with her and her grandchildren, asked the complaining witness to pick up the complaining witness. She said a separate relationship with her daughter, her grandchildren, informed the defendant that she had a complaining witness. She said a separate relationship with her daughter, and informed the defendant that to begin arguing with her. She then expressed that she hated him, and this made the defendant more upset. And arguing with her, she then expressed to her she hated him, and this made the defendant more upset. When it was stated she hit, he told her to hit him and had face her 3 times before. When it was stated she hit, slipping and falling. This close caused her to face her 3 times before losing balance, slipping and falling. When it was stated she got up and hit her face on their bed. She was laying on the bed, she got up and the wall and covered her body with blood. She was laying on the approximately 10 minutes close to the wall and covered her body with blood. Continued to argue with her. Anyone is saying that crawl on bed and grab by and stroll over. Her back was on the mattress. Continued to argue with Pierce's body weight. Crawl on bed, grabbed her with both hands on her upper arm. Her back was on the mattress and used to say this caused her pain. She used both hands to free one of her arms and use her hand to grab. Complainant said this caused her pain. She was genital area to free one of her arms and use her hand to grab, making him go for the defendant's genital area. The defendant then used his right hand and punched the complaining witness on her mouth, causing pain and visible injury. The defendant then used his right hand and punched the complaining witness on her mouth, causing pain and visible injury. And the complaining was added that the law enforcement officers observed visible injuries, including large pulp bruises on the arms. Is it the law enforcement officers observed visible injuries, including large pulp bruises on the arms?
Laser, you hearing this?
And injuries to the top and bottom.
So she's the initial aggressor. Laser, you hearing this? Correct? Interesting.
Your Honor,
So she's the initial aggressor though,
she's.
correct?
Your Honor.
So he says, hey, hit me, antagonizing. She gets into it. She pops him, what, 3 times? He says, hey, hit me, antagonizing. She gets into it. She pops him, what, 3 times? In the mouth, you say?
So Your Honor, the only thing I would ask is,
Don't say anything.
this is not home court's case, if we just. Your Honor, the only thing I would ask is the prosecutor to be here. This is not home court's case, if we just stand down. Yeah, if he has to be more to add. To be here. I don't know if he's asked the court yet, if he has anything more to add until we can. I would just.
Mr. Sullivan, just do me a favor, will you just take a seat with me in the jury box? I'm gonna get, Mr. Sullivan, just do me a favor, will you? I'm gonna seat with me in the jury box. I'm gonna get, I'm gonna also, if you don't mind, I'm gonna point him something as well, so we can do it.
Just take me, and I'll email.
All right, thank you. Just Guzman.
Yes.
Mr. Guzman, you're charged with displaying the just license plate.
Yes.
6 months, Guzman, you're charged with displaying the just license plate. We're going to do 6 months in jail, and you have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one.
On March 24th, 2025, at around 11:20 a.m. On March 24th, 2025, officers were dispatched at around 11:20 a.m. At 2520 officers were dispatched to a B&B call in Harris County, Texas. At 2520 Airline Drive, officers in Harris County, Texas. Upon vehicle parked in the west side, officers observed the defendants. Vehicle parked in the west side Houston Farmers Market. With the front passenger window of the Houston Farmers Market. With the front passenger window conducted a vehicle check on the temp license plate. Officers conducted a vehicle check and returned a dot match on the temp license plate. And returned a dot match vehicle. At 12 p.m., the defendant's vehicle. The defendant arrived on scene. At 12 p.m., says that he was the owner of the vehicle. The defendant arrived on scene. The defendant was retained as the owner of the vehicle. Defendant say he purchased the vehicle retained 5 years prior. Defendant say he purchased the vehicle in Florida 5 years prior. An additional fee from the seller in Florida. And paid an additional fee from the seller. But the seller did not change the title. Defendant stated he met a woman, did not do that. Defendant stated he met a woman WhatsApp who offered him a fake temporary license plate on WhatsApp. Who offered him a fake temporary license plate, which he purchased. Defendant stated he has been driving the vehicle, which he purchased. With fake temporary license driving the vehicle for 4 years, fake temporary license plate. The defendant was ID'd by Guatemala for 4 years. The defendant was ID'd by Guatemala.
There's sufficient probable cause to find that there's sufficient probable cause to go forward. If you do not have a Texas driver license and liability insurance in relation, you do not have, you are not allowed and liability insurance in this line. You are not properly licensed. I don't care what you need to do in this line. No, you're not properly licensed and signing insurance. This is an affidavit that you're going to swear to be signing what promise you. You cannot justify driving for any reason. Swear to that I find what you do. I cannot justify driving for any reason. I don't find what your immigration status is. I will revoke your bond, but if you're not in this country with permission, I don't know what your immigration status is. But if you're not in this country with permission, they will put a detainer on you. And you will be stuck like an immigration finds you. They will put a detainer on you. And then you get shipped off to like Chuck in there.
Whoa, pause right here. Look at this pattern. 1 minute you're walking to the gas station, the next you're hit with a wooden stick. The court has to weigh public safety seriously here. This isn't just a small scuffle, it's assault with a weapon, which carries real jail time.
You're not responding to phone call, you understand. Likewise, I will revoke your bond.
Yes.
Okay. I'll have you sign a receipt. We'll have you swear to that you're not gonna drive, and after that, you're free.
Yes.
Okay. I'll have you sign a receipt of report, we'll have you swear to take out to drive, and after that, you're free to go. Hey,
Aaron Durden, bond violation report, you said bring him today, he's here.
hey,
Aaron,
come up, Mr. Durden.
bond violation report, you said bring him today, he's here.
Another.
Come up, Mr.
bond
Durden.
Violation.
You're here.
It is now alleged. Another bond violation. The client was instructed to install an ignition interlock device, not to tamper with the device. The client was instructed to install an ignition interlock device to 320.5 to blow into it. 8 tests from 220 to 320.5. You skipped 8 tests, please.
All those violations except one are on the same day. If you look at the photos, the person that's, there's only one person in any of the photos on the same day. If you look at the photos, the person that's, there's only one employee in any of the photos, they didn't understand the deal. All the other pictures show nobody in the truck. Drive the truck. But they didn't understand the deal. They just left the truck. All the other pictures show nobody in the truck to keep the climate control on. They just left the truck running while they were doing work. Pre-trial last week asking them to try to get the photos clarified before the violation, so we could see who was actually driving the truck. The photos before the violation, so we could see who was actually driving the truck.
Guys, does he have a blow schedule that he's supposed to blow? He has a blow schedule. Guys, does he have a blow schedule that he's supposed to blow? And he's not blowing. He has a blow schedule.
Are you not blowing at certain times?
He's supposed to blow at certain times.
That's not true, Your Honor.
And he's not blowing. I have here 8 skip tests.
That's not, so one of my guys was driving the truck, and he did not, so I didn't instruct one of my guys was driving the vehicle truck, and he did not just leave it running. I didn't instruct him that when you stop the vehicle, wasn't informed about that. You can't just leave it running.
But it was rolling retests that were skipped.
Wasn't informed about that.
That's the allegation, rolling retests. So somebody started the truck that were skipped, got out of the truck. That's the allegation, rolling retests. Just kept saying, somebody started the truck. If you look at the time, out of the truck, they're like 5 minutes apart. And it just kept saying, blow. If you look at the times and dates, they're like 5 minutes apart for 15 or 20 minutes.
What specifically? Yes, Judge, I do see that it's the rolling retest as far as.
I haven't either, but bottom line, he's supposed to test at certain times. I haven't.
Here's the tricky part. He claims the officers keep targeting him, yet he keeps returning to the same spot. This is classic recidivism territory. Judges often have to balance empathy with accountability. Letting him roam freely risks public safety, but too much confinement could derail any chance at reform.
Time is he supposed to someone else blow? And did he actually do it on that times, or so? Let me see what they say in there. That's what I like. So let me see what they say in there.
Odiambo on today's docket. He's doing the DWI-PTI program. He just gets a little more time to get the device. He's doing the DWI-PTI program. He just gets a little more time to get the device. It's hyphenated.
Last name is
Marina Odiambo. She's been having some financial issues, and so he's trying to get some money together to get the alcohol monitoring device. She's been having some financial issues, and so he's trying to get some money together to get the alcohol monitoring device. To get the 3. And we also need to submit the industry affidavit, but he's provided that to me. There's no way to get 2 weeks just for him to get the device. That's all we need. And he has that filled out. It's just I need to get a
everything now because we
PDF
can
copy
scan
of
it,
it.
bring him back, and I can.
No, just he has like he took photos of it, and that's not going to work
everything now
for
because we
them.
can scan it, bring him back.
No, just he has like he took photos of it, and that's not going to work for
I'm
them.
not giving you any more time. This is 200, and you won't have it done. I'm going to immediately set. I'm not giving you any more time. I have to leave bargain from the state. You won't have it done. I'm not giving you any more time. Set you for trial, or you're going to leave bargain everything from the state done. But I'm not giving you any more time. You need to submit the affidavit today, not tomorrow. By that, not next week. You need to submit any time to affidavit today. They're going to grant tomorrow. Not next week. I will not give you any more time after this 2 weeks. See if you don't have it done, I will bring you back. I will not give you any more time after this 2 weeks. If you don't have it done, do you understand? I will bring you back day. Okay.
Thank you, Judge.
Final 2 weeks. You have it done.